Rome Statute of the International Criminal Court, Regulations of the Court. Article 46. Removal from office. 1. A judge, the prosecutor, a deputy prosecutor, the registrar or the deputy registrar shall be removed from office if a decision to this effect is made in accordance with paragraph 2, in cases where that person a. is found to have committed serious misconduct or a serious breach of his or her duties under this statute, as provided for in the Rules of Procedure and Evidence, or b. is unable to exercise the functions required by this statute. 2. A decision as to the removal from office of a judge, the prosecutor or a deputy prosecutor under paragraph 1 shall be made by the Assembly of States Parties, by secret ballot. A. In the case of a judge, by a 2/3 majority of the states parties upon a recommendation adopted by a 2/3 majority of the other judges. B. In the case of the prosecutor, by an absolute majority of the states parties. C. In the case of a deputy prosecutor, by an absolute majority of the states parties upon the recommendation of the prosecutor. 3. A decision as to the removal from office of the registrar or deputy registrar shall be made by an absolute majority of the judges. 4. A judge, prosecutor, deputy prosecutor, registrar or deputy registrar whose conduct or ability to exercise the functions of the office as required by this statute is challenged under this article shall have full opportunity to present and receive evidence and to make submissions in accordance with the Rules of Procedure and Evidence. The person in question shall not otherwise participate in the consideration of the matter. Article 47. Disciplinary measures. A judge, prosecutor, deputy prosecutor, registrar or deputy registrar who has committed misconduct of a less serious nature than that set out in Article 46. Paragraph 1 shall be subject to disciplinary measures in accordance with the Rules of Procedure and Evidence. Article 48. Privileges and immunities. 1. The court shall enjoy in the territory of each state party such privileges and immunities as are necessary for the fulfillment of its purposes. 2. The judges, the prosecutor, the deputy prosecutors and the registrar shall, when engaged on or with respect to the business of the court, enjoy the same privileges and immunities as are accorded to heads of diplomatic missions and shall, after the expiry of their terms of office, continue to be accorded immunity from legal process of every kind in respect of words spoken or written and acts performed by them in their official capacity. 3. The deputy registrar, the staff of the office of the prosecutor and the staff of the registry shall enjoy the privileges and immunities and facilities necessary for the performance of their functions, in accordance with the agreement on the privileges and immunities of the court. 4. Counsel, experts, witnesses or any other person required to be present at the seat of the court shall be accorded such treatment as is necessary for the proper functioning of the court, in accordance with the agreement on the privileges and immunities of the court. 5. The privileges and immunities of a. A judge or the prosecutor may be waived by an absolute majority of the judges. B. The registrar may be waived by the presidency. C. The deputy prosecutors and staff of the office of the prosecutor may be waived by the prosecutor. D. The deputy registrar and staff of the registry may be waived by the registrar. Article 49. Salaries, allowances, and expenses. The judges, the prosecutor, the deputy prosecutors, the registrar and the deputy registrar shall receive such salaries, allowances, and expenses as may be decided upon by the Assembly of States Parties. These salaries and allowances shall not be reduced during their terms of office. Article 50. Official and working languages. 1. The official languages of the court shall be Arabic, Chinese, English, French, Russian, and Spanish. The judgments of the court, as well as other decisions resolving fundamental issues before the court, shall be published in the official languages. The Presidency shall, in accordance with the criteria established by the Rules of Procedure and Evidence, Determine which decisions may be considered as resolving fundamental issues for the purposes of this paragraph. 2. The working languages of the court shall be English and French. The rules of procedure and evidence shall determine the cases in which other official languages may be used as working languages. 3. At the request of any party to a proceeding or a state allowed to intervene in a proceeding, the court shall authorize a language other than English or French to be used by such a party or state, provided that the court considers such authorization to be adequately justified. Article 51. Rules of Procedure and Evidence. 1. The rules of procedure and evidence shall enter into force upon adoption by a 2/3 majority of the members of the Assembly of States Parties. 2. Amendments to the rules of procedure and evidence may be proposed by a. Any state party, b. the judges acting by an absolute majority, or c. the prosecutor. Such amendments shall enter into force upon adoption by a 2/3 majority of the members of the Assembly of States Parties. 3. After the adoption of the rules of procedure and evidence. In urgent cases where the rules do not provide for a specific situation before the court, the judges may, by a 2/3 majority, draw up provisional rules to be applied until adopted, amended or rejected at the next ordinary or special session of the Assembly of States Parties. 4. The rules of procedure and evidence, amendments thereto, and any provisional rule shall be consistent with this statute. Amendments to the rules of procedure and evidence as well as provisional rules shall not be applied retroactively to the detriment of the person who is being investigated or prosecuted or who has been convicted. 5. In the event of conflict between the statute and the rules of procedure and evidence, the statute shall prevail. Article 52. Regulations of the Court. 1. The judges shall, in accordance with this statute and the rules of procedure and evidence, adopt, by an absolute majority, the regulations of the court necessary for its routine functioning. 2. The prosecutor and the registrar shall be consulted in the elaboration of the regulations and any amendments thereto. 3. The regulations and any amendments thereto shall take effect upon adoption unless otherwise decided by the judges. Immediately upon adoption. They shall be circulated to states parties for comments. If within 6 months there are no objections from a majority of states parties, they shall remain in force.